Hello and welcome to the first lecture wherein we're going to be discussing how to solve polity questions in the civil services preliminary exam. This lecture is going to contain two parts. The first part, which is going to be a brief part, is where I will walk you through the broad principles that you should keep in mind before you try and attempt a polity prelims question. And the second part, which is the longer part, is where we will solve all polity previous year questions from the last 10 years, which is 2011 to 2021, from the topics, the preamble, territory, citizenship, fundamental rights, directive principles, and fundamental duties. So let's get started. In the course of this lecture, whenever I will discuss a previous year question, you're more than welcome to pause the video, try solving the question on your own, and then you can verify your answer or your approach with the way I discussed the question. So let's begin. There are essentially three sets of principles that are in play when you're trying to solve polity questions. The first is academic, the second is logic and inference based, and the third are your tricks of the trade. As far as your academic principles are concerned, there are four golden rules while solving polity questions. 1. Democratic mandate. 2. Federal balance. 3. Separation of powers. And 4. Checks and balances. I have discussed all of these four rules in the right amount of detail in lecture number 2 of the Magna Carta series, which is nothing but a prelims crash course for the upcoming civil services exam. I'll quickly run you through these four rules. Democratic mandate basically means you must have some form of democratic backing if you want to perform a higher or an advanced democratic function. For example, only elected members of the legislative assemblies will participate in the respective elections to the Rajya Sabha from their states. It's because elected members have the mandate to perform a higher electoral process. Rule number 2, federal balance. This contains two parts. First, the center is stronger than the states, and whenever the center is stronger than the states are going to be given a hollow appeasement to sort of neutralize the process. For example, the states play no role whatsoever in territorial changes that are carried out. In fact, any territorial change can only be carried out by the parliament through a law. Now, this means the center is stronger than the states. Now, what is the hollow candy or the hollow appeasement to the states? In the case of an internal reorganization, before the bill is tabled in the parliament, the president refers the bill to the concerned state legislature for their opinion. The opinion of the state legislature is not binding on the president, and therefore it makes for a hollow candy. Third, separation of powers. The legislature, the executive, and the judiciary are three primary branches of the government, and they have to be kept as away from each other as possible within the realms of parliamentary democracy for their efficient functioning. This means two things: inter-separation of powers and intra-separation of powers. Inter-separation of powers means between L, E, and J. For example, the conduct of the judges cannot be discussed on the floor of the parliament unless the parliament is looking to vote to remove the judges. This is an example of inter-separation of powers. The second type of separation of powers is intra-separation of powers, which is within L, within E, and within J. So, for example, members of the Lok Sabha and the Rajya Sabha can only sit in their respective houses. The only people who are exempted from this restriction are ministers and the Attorney General because they play a higher function. But members of the Lok Sabha who are not ministers cannot ordinarily go and sit in the Rajya Sabha. This is an example of intra-separation of powers. Then you have checks and balances, which is a natural corollary of separation of powers. If the legislature, the executive, and the judiciary are the three highest power centers of the country. The only people capable of keeping a check on these three are these three. Like separation of powers, checks and balances also have two sides to it. One, inter checks and balances, and two, intra checks and balances. So, inter checks and balances would mean, for example, the judiciary, or more specifically the Supreme Court, has the powers to strike down any law which is made by the Parliament which compromises or which allegedly violates a fundamental right. Similarly, judges of the Supreme Court can be removed through a special majority of the Parliament. This is a simple example of inter checks and balances. Similarly, intra checks and balances. For example, between the Lok Sabha and the Rajya Sabha, the Lok Sabha enjoys a larger function than the Rajya Sabha. The Lok Sabha enjoys higher powers than the Rajya Sabha in financial matters, more specifically a money bill. This is also because of rule number 2, as Rajya Sabha is a representative of the states and we cannot give them equality of status when it comes to certain key functions at the center. Now, these 4 golden rules, you can study them in detail if you want to by watching the lecture number 1.2 of the Magna Carta series. I assure you they will be of incredible help and they will never ever fail you, which means these are 100% applicable no matter what the polity question is. Then we have some basic principles which are based purely on logic and inference, and this inference has been drawn by the way UPSC has answered its own questions through their answer keys, which gets released a year after the process is over. This is very important. Like academic principles which are 100% foolproof, logic and inference is also 100% foolproof. What is the first logic and inference point that you should pay attention to? 1. If the prelims question says, according to the Constitution, or the Constitution refers to, or under the Constitution, or the Constitution provides for, then only that option which is explicitly in black and white, in those exact words mentioned in the Constitution, will be the correct answer. Any assumption, any derivation, any sort of 2 plus 2 equals 4, that kind of an interpretation, any commentary on it will not be the correct answer. For example, there's a prelims previous year question that says, according to the Constitution, judicial review means checking of the constitutionality of the law. Now, judicial review means checking of the constitutionality of a law is correct, but judicial review is nowhere mentioned in the Constitution. So that option becomes incorrect, because according to the Constitution, judicial review means nothing. It is nowhere mentioned in the Constitution. The term judicial review does not exist. You can apply this to separation of powers, checks and balances, federalism, judicial activism, and so on and so forth. This is important. If the question says, according to the Constitution, that means it must be explicitly mentioned in the Constitution. That's your first logic and inference. Second, you can often use what I call the devil's advocate technique. A devil's advocate technique is a common strategy that we often use in trial law. What it basically means is, if you can argue the opposite and the opposite to the option seems to be correct, then the option is wrong. For example, if the question says, which of the following is a correct interpretation of liberty? And one of the options is the absence of tyranny or the absence of a dictatorial government. Now argue the opposite. Just because a country does not have a dictatorial government does not necessarily mean the citizens have liberty, because democratically elected governments can also make laws which compromise the liberty of its citizens. There are numerous examples in and around it. So that option becomes the incorrect option. It's a very good method to eliminate things that you've never heard of. So argue the opposite, right? Now, third, any body, any institution which has been mentioned in the question and you have no idea about it, you've never heard of it, right? If the institution has any quasi-judicial power or it has any regulatory power, it must always be backed by a law. It must always be statutory in nature. Otherwise, it will not have the powers to pass those orders. Extremely important. For example, there's a question that says, let's say the Telecom Regulatory Authority of India, right? It regulates the telecom sector. It has to be backed by an act which recognizes the Telecom Regulatory Authority of India, or for that matter, the Securities Exchange Board of India, or for that matter, the Censor Board. All of these have to be backed by acts so that they have the powers to regulate. A regulatory body must always be a statutory body. Fourth, polity questions should never be seen in isolation. They must always be cross-referenced with society and what you observe in and around you. Real life examples must justify the option that you think is correct. For example, let us say there is a question that says a consumer does not have to pay any fee whatsoever to file a case in a consumer court. If that was the case, then consumer courts would be overburdened with fake cases, which also justifies our second principle, which is the devil's advocate. Or for example, a right to property is only and only available to citizens. If a right to property is only available to citizens, then no foreigner can invest in property in India. So what happens to India becoming a welcoming nation for foreign investments and for foreign entry if foreigners do not get rights to invest in property? We can understand that there can be restrictions on agricultural property, but property as a whole, property in general, can't be restricted for foreign investment. Last, for example, the UPSC polity questions are often very similar to CSAT comprehension questions, wherein they write extremely heavy, extremely complex statements. What you must do is simplify those complex statements. Take a pen or a pencil and try to simplify the statement in lesser words right next to the question. For example, there was a previous question on which of the following is the definition of a state, and they had very, very long options. Just identify what were the key components that they were talking about with respect to what is meant by state. You will be able to then look at the question with greater clarity and arrive at the answer far more quickly. So these are also 100% effective. You will never go wrong. If you're using any of these techniques to solve the question, I guarantee you, you will not go wrong. Now comes the tricks. Now, with respect to tricks, some of them work all the time. Some of them may or may not work because the UPSC can change the way it sets its pattern. What definitely works is inherent contradictions within the options. For example, this works very well with a question which has multiple statements. So which of the following about directive principles is true? Statement number 1, they're enforceable by court. Statement number 2, they're not enforceable by court. Both of these statements cannot coexist at the same time. Never ever. So either statement 1 will be correct or statement 2 will be correct. At no point of time will both of them be correct. So it's very easy to eliminate with the more obvious choice. But this can assist you in arriving at an answer, may not necessarily guarantee you an answer. This is also something which used to work 3-4 years ago, but over the last 3 years or so, more specifically 2 years, the UPSC has been smart enough to change the way it arranges its options. This is Again, very useful for multiple choice options. For example, there is a question that says, which of the following statements is true? And there are four options. And out of these four options, except for option C, all of the other options definitely include statement 1. So if you can eliminate statement 1, then you can easily arrive at an answer blindly without thinking of anything else. This used to work for sure 3-4 years ago, but now you have to be a little more careful with it. This is again something which the UPSC has taken cognizance of, but in case a statement says all, none, any, everything, everyone, none at all, you have to be very, very careful while examining that statement. You must look at that statement with an eye of suspicion, and only if you are very sure would you only mark that statement to be correct. And this is something which is a silly mistake that a lot of times candidates do, which is the UPSC will sometimes ask you which of the following is incorrect. But because you may sometimes be in a hurry, or you may be under stress, or you may be nervous, what you would end up doing is you will try and think of which of the following is correct. So a standard practice should be, if it is a multiple statement question and they're asking you which of the following is incorrect or correct, circle what the question is asking you so that visually you're always aware of the same. These are the only basic principles that you should follow. What we're going to do now is use these principles and solve all polity questions from part 1, 2, 3 and 4 of the Constitution right before you right now. Okay, so let's move. We're going to be looking at the preamble, territory, citizenship, rights, directive principles and duties. The reason I've clubbed all of them together is because over the last 10 years, there are hardly any questions from territory and citizenship, and preamble, rights, directive principles and fundamental duties are often asked together in the same question as well. So it will also give you practice if you try to solve these questions together, right? On an average, you can expect about 4 to 5 questions from this topic on a yearly basis. This year, I'm definitely expecting about 5 questions from here. If not 5, at least around 4 or 5 questions must come, because as you can see, over the last 2-3 years, there has been a constant presence of these topics, and you must get these questions correct. Especially last year, the questions were fairly tricky, but not unsolvable. So let's begin. We have to be patient, we have to be calm, the best way to do this exam is to do the actual exam as if you're doing a mock exam with that degree of calmness. If you're calm, you'll be able to think, you'll be able to cross-check, and you'll be able to verify. Don't be scared, don't be nervous. Let's begin. The first question. You can pause the video and try and solve it if you want to. With reference to India, which means it's talking about India, it's not referring to the Constitution, which is also a part of India. Consider the following statements. There is only one citizenship and one domicile. A citizen by birth only can become the head of the state, which is the president, which means only a person who has citizenship by birth can become the president. Somebody who has naturalization, registration, or descent or incorporation can't. A foreigner once granted citizenship cannot be deprived of it under any circumstances, right? Under any circumstances. And the question is asking which of the following is correct. Now, as we can see, we just glance through the options and we see that option number 3 is present in 2 of the options. So if I can eliminate option number 3, I'll only have to choose between option number 1 and option number 2. What does option number 3 say? A foreigner once granted citizenship cannot be deprived of it under any circumstances. If that was the case, then how would you look at re-examining citizenship under the context of the Citizenship Amendment Act? If that was the case, then why would the Citizenship Act of 1955 have provisions on how to lose citizenship? For example, termination, renunciation, or fraud. Citizenship is a legal exercise. It's a legal exercise on the basis of which, of you fulfilling certain criteria, are you granted a certain entitlement. If you have committed fraud in terms of submitting the right document, your citizenship can be taken back. It is a legal exercise. There's nothing that can't be taken back as a legal entitlement. That's just the due process of law. So absolutely, option number 3 is incorrect, which means C and D is wrong. Now we only have to choose between A and B. A citizen by birth can only become the head of the state. Now we understand that India comes from the context of the partition, which means we've had a fairly destructive and a fairly complicated past. And India, unlike the US, has not discriminated on the basis of how one becomes a citizen and the benefits that one gets out of it. In India, a citizen, once a citizen, as long as you're a citizen, you're as much of a citizen as anybody else. Which means this statement is also incorrect. Your correct option should be A, that there is one citizenship and one domicile. Even if you think domicile here means domicile of the state, you cannot have more than one domicile of a state. That would be considered perverse under law. So your correct option would be option number A, right? There you go. Now, a difficult question. How would you do it? Because 90% of the students who wrote the exam last year did not know how to solve this question. Let us see if we can. Consider the following statements in respect to Bharat Ratna and Padma awards. Statement number 1. Bharat Ratna and Padma awards are titles under Article 18 Clause 1 of the Constitution of India. Padma awards, which were instituted in the year 1954, were suspended only once. Again, this makes us look at the statement with a degree of suspicion. The number of Bharat Ratna awards is restricted to a maximum of 5 in a particular year. Alright. Now, which of the following statements are not correct? Which means any statement which is incorrect is the option that we are looking for. Bharat Ratna and Padma awards. These are essentially awards. These are not titles. Titles are military or professional in nature. And Article 18 Clause 1 says titles are defined. Titles are not the same thing as awards. So they are not even titles as per Article 18 Clause 1. Which means this statement is wrong. So any option which has 1 will definitely be a correct option because the question is asking for incorrect. This is fairly easy, everybody would have gotten this, that an award is not the same thing as a title. If it was, then it would have just called it a title in the first place. Now, Padma awards, which were instituted in the year 1954, were suspended only once. Now, argue the devil's advocate theory and try to understand this with current context or generally society around you. This means you can suspend the awards. There is no reason why you can't. These awards are nothing but celebration of achievement, and these awards are given by the government, and these awards will also contain at least some financial reward. And these awards are given by the government to recognize the pinnacles of achievement of its citizens or people in general. What if the country is going through a hard time? What if the country is facing some of the most difficult moments in history? would you still want to give an award around that time? No. Since 1954, our country has seen at least 3 wars, has seen the emergency, has seen drought, has seen massive scale riots. It's possible that if the awards had to be suspended, there would definitely be more than one occasion for it to happen, right? And if the awards have to be suspended, they have to be suspended by the government. And what if the government was not fully functional? Emergency is not a fully functional government. So therefore, it is fairly possible that these awards could have been suspended more than once. So this also seems to be an incorrect option. So 1 and 2 are definitely there, which means this and this and this are gone. The only option that is left is D. So even if you are not sure that the number of Bharat Ratna awards is restricted to 5, it's actually 3, but it's okay. You are not supposed to know this. Think about it. The Bharat Ratna is the highest civilian honor in the country. If the Paramveer Chakra is the highest military honor in the country, the Bharat Ratna is the highest civilian honor. It is the very zenith of achievement in the civilian space. If you're giving 5 people the highest award, aren't you diluting the sanctity of the award? It seems like it's too much, right? So that is why you would usually not keep it at a high number. That would be my guess. Because honestly, when I saw this question for the first time, I did not know that the Bharat Ratna is restricted to 3 a year. But the logic that I would have used is that 5 seems to be too big a number, so it does not seem to be right. So the correct answer according to me should have been D. But in a question like this, keep this in your second round of attempts. Don't solve a question like this by sitting on it in the first round of you trying to solve questions, because you can get stuck and you can waste a vital amount of time. So the answer here would therefore be D, 1, 2 and 3, right? Okay. Now, the next question. Again, a question that did sort of take people by a little bit of surprise. Consider the following statements with respect to right to the city. You see, you can still get around to it. Again, a question that you should only attempt in the second round of you trying to solve a question. So, the right to a city is an agreed human right, and the UN Habitat monitors the commitments made by each country in this regard. The right to the city gives every occupant of the city the right to reclaim public spaces and public participation in the city. Every occupant to reclaim public spaces, which means to use public spaces. A lot of people thought this meant to occupy it permanently, but that's not what it means. And participate in the happenings of the city. The right to the city means that the state cannot deny any public service, again, an extreme word, or facility to the unauthorized colonies in the city, right? Now, which of the following is or are correct? Now, take a breath, think. Out of the 3 statements, which is the easiest to eliminate? Which is the easiest to eliminate? Right to the city means the state cannot deny any public service. Apply the devil's theory and societal context. This means illegal colonies, illegal houses, encroachments which are illegal in nature should be given the same benefits as everybody else. So if you have an illegal dwelling which is stealing electricity, they should still be continued to give electricity, to be given electricity. They should still be given road access and all other social and civic amenities despite the fact that they're illegal. If you're illegal and you're given a legal entitlement, does that not violate principles of natural justice? Does that not violate what is called due process of law? And therefore, this is definitely wrong. So any option which has 3 is eliminated. Now either 1 is correct or 1 or 2 is correct, which means 1 is definitely correct. This is for sure. We may not be sure about option 2, but we are definitely sure about option 1. That right to the city is basically a concept under a UN agency called UN Habitat. Now, what else do we know about UN agencies coming up with such kind of rights? For example, the Universal Declaration of Human Rights. For example, the International Covenant of Civil and Political Rights. For example, the International Covenant of Economic, Social and Cultural Rights. These are some of the UN documents that we are aware of, right? Aren't all of these documents and what is mentioned in these documents usually all encompassing in nature? They're usually very, very broad in nature. UN Convention on Rights of Child for that matter. They're all very, very open-ended documents. And all that this document is trying to say is that every resident of the city has the right to use the infrastructure of the city and participate in the events of the city. At least this part makes sense because you can equate it with urban local self-government. So there is a very good chance both 1 and 2 are correct. So if you have to take an elimination guess, then you should look at option number C, because it seems like they are complementary to the nature. This organization is supposed to monitor the commitments. Does not mean every nation has to provide the same degree of rights which are mentioned in the right to city document. So therefore, I would have marked option C. Again, I will be honest, when I saw this question for the first time, I was not aware of the technical details. But if I had to take a chance, if I had to try an answer, I would have taken option number C. Okay? Now, there you go. Now, this again, a question which confused a fair bit, but this was an easy question. Here we are going to apply the simplification technique. A legislation, this is a rather poetic question. A legislation which confers on the executive or the administrative authority an unguided and uncontrolled discretionary power in the matter of application of law violates which one of the following articles of the Constitution? Seems tough. Article 14, which is equality before law. Article 28, which is related to religious institutions. Article 32, which is constitutional remedies. And Article 44, which is a directive principle of state policy. Right? Now, simple. If something has to violate an article of the Constitution, it cannot be a directive principle because they are not justiciable in nature. So it doesn't matter what is under Article 44, it does not matter because it's non-justiciable in nature. Now, let us simplify this. All that it is saying is, there is a law which is giving some powers to the executive or the administration, which is the same thing. This power that is given to the executive authority is essentially an uncontrolled power. It is a discretionary power, which means if the executive has to apply this power, it will apply this power arbitrarily. If it had to apply this power to two people X and Y, they have absolute freedom to apply this power unequally to X and Y. And the reason they're able to do this is because a law is giving them this power to do so. So this law is treating X and Y differently because of the power given to the administration. So a law which treats people differently and unequally violates Article 14. So this should be your answer. Just break it down into a flow chart. Simplify it, you should be able to arrive at the answer. This is definitely not the answer because it has nothing to do with religion. A lot of people thought Article 32 should be the answer, but nowhere does the question say it is restricting the powers of the people to go to court. Article 32 is a guarantee for the people to go to court, to go to the Supreme Court. Nowhere do you find the word Supreme Court mentioned here. So this is not the answer, this is not the answer. The answer is A, Article 14. Okay? A simple simplification technique. Next, again, we'll use the simplification technique. Which of the following best defines the term state? We'll try to simplify it as we get along. Okay? A community of persons permanently occupying a definite territory, independent of external control, which means it is also sovereign, and it possesses a government. Okay? Second option, a politically organized group of people, a politically organized people of a defined territory and possessing an authority to govern them, so there is a government, to maintain law and order, protect their natural rights, and safeguard their means of sustenance. All of this is a function of government only. It is the government which is supposed to govern, maintain law and order, protect their natural rights, and safeguard their means of sustenance. It is the function of the government. And natural rights have to be converted into legal rights. So this anyways sounds a tad bit shady. Now look at option number C. A number of persons who've been living in a definite territory for a very long time with their own culture and government. This is with their own government, which means their own locally set up government. Okay? Now, fourth, a society permanently living in a definite territory with a central authority, which means there is some form of government, an executive responsible to the central authority, that means it sounds like a parliamentary government, and an independent judiciary, which is also a branch of government. They're essentially describing a parliamentary democracy, largely comes under the ambit of government. So if you see, the first option is talking to you about territory, state and government. The second option is talking to you about territory and government. The first option is territory, sovereignty and government. The second option is territory and government. The third option is territory, culture and government. The fourth option is territory and government. So obviously B and D is out because they are talking about lesser ingredients of government. Now, what is more important for a state? Sovereignty or culture? Just because you've been living for a long time does not necessarily mean you are sovereign. You have to be sovereign only if you're independent of external control. A country is not a country if it's not independent. So sovereignty is a precondition. The rest of the factors are the same. Simplify it, the answer should be A. Alright? You don't have to know the theories of political science to answer this, though I admit students of political science may have an advantage while attempting a question like this, but that does not mean the rest of us can't do this. Okay? Now, next. Question number 6. Far too simple for us to bother. Right to privacy is protected under which article of the Constitution? 15, 19, 21 and 29. Now, be very careful about this. Unless a fundamental right has been directly derived from an article, for example, right to information is derived from the right to freedom of speech. It has been declared as a fundamental right under the freedom of speech and expression. That if people have the right to express themselves, then they also have the right to have the right information so that they can express themselves better. Unless that is the case, and one of the options says Article 21, please assume it's Article 21 because it's the largest all-encompassing umbrella right. So Article 15 is related to non-discrimination and education reservation, does have nothing to do with privacy. Article 29 is cultural and educational rights for minorities. We are stuck with 19 and 21. Now, of course, 19 also has a relationship with privacy. For example, if you are performing surveillance on journalists, you're violating the privacy of journalists, therefore compromising their freedom to expression. But that is a correlation. A direct interpretation of life and liberty is a violation of privacy. That's what the Supreme Court also says, that Article 21 is primarily how the privacy right originates from, but it can also have manifestations in other rights. But the primary right which gives birth to the right of privacy is, of course, Article 21. Your answer would be C. Remember this, people often go wrong here. They commit a silly mistake because they think, why is the UPSC asking such an easy question? Why is the UPSC insulting our preparation? They are not. It is primarily because a lot of times things seem too simple, too textbook to be true, but there are questions which are offered very, very simple. Alright, so your correct answer here becomes C. Next, what is the position of the right to property in India? Here we can apply the whole social relatability trick. A legal right available to citizens only, a legal right available to any person, a fundamental right available to citizens only, a neither fundamental right nor a legal right. Alright, what do we know for sure? What we know is this used to be a fundamental right, but now has been moved to something in the Constitution called Article 300. Everybody knows right to property is no longer a fundamental right, but it's a constitutional right. Okay, so definitely option C is out. Now we are left with legal right available to citizens only, legal right available to any person, neither a fundamental right nor a legal right. Remember, a constitutional right and a legal right have similar manners of enforcement. The Constitution is a law after all. So if your legal right gets violated, you can go to the High Court under 226. That also implies to a case of the constitutional rights. We've discussed this in the rights chapter in the Magna Carta. I think it's lecture number 5, 5.1 and 5.2. So I think you should revise this in case you haven't. So constitutional right and a legal right are more or less the same in terms of enforcement, which means it is definitely a legal right. It is definitely not a fundamental right. So this is also out. Now, is it a legal right only for citizens or is it a legal right for anybody? Now apply the context. If right to property was a right only for citizens, then how would foreigners get the opportunity to invest in India, to live in India, to buy a home in India, to set up a restaurant in India, to set up a property in India, to set up a manufacturing unit in India? How would you then go all over the world and request the world to come invest in India if you could not even buy property in India, right? That would then, flip the entire come invest in India, welcome to India, sort of a foreign policy principle that we have. So therefore, the option is B. That is your correct option. This is also given in your NCRTs, by the way. But anyway, so your option is B. Now, under the Indian Constitution, the first inference, this has to be explicit. It has to be mentioned as it is under the Constitution. The concentration of wealth violates what? If far too less people have too much wealth, what is it violating? The right to equality, the directive principles of state policy, the right to freedom, or the concept of welfare. Now, if it is under the Constitution will have specific provisions. The Constitution does not have concepts written down. It has provisions written down. So this is automatically eliminated. The concept of welfare is automatically eliminated, right? Now, think about it. There is a contradiction. If I have the freedom to work, I have the freedom to be in a part of any trade, profession, whatever it might be. This means I have the right to work as hard as I can, to amass as much wealth as I can, right? So if I have the freedom to work, to earn some rewards, then how is it even concentration of wealth? How is it violating my concept? How is it violating the essence? Concentration of wealth is contradictory to the right to freedom. If people have the freedom to work and therefore work with the objective of earning as many rewards as they can, it would therefore be contradictory to concentration of wealth, because this is a natural outcome. This will lead to concentration of wealth. It will not violate concentration of wealth. So this is also out. Now you are left with A and B. Right to equality means two people have to be treated equally before the law, and people from similar circumstances must be treated similarly. There is no law here. It's a principle. So right to equality has nothing to do with concentration of wealth. And this, therefore, by elimination, is your right answer. In fact, 39B and C is often used in the context of a relationship with fundamental rights, that 39B and C are the only two directive principles which are superior than 14 or 19 if these are the only two obstructions as per the Minerva Mills judgment. So this is a question that can be solved. The answer is, of course, B. Next. There you go. The preamble to the Constitution of India is, again, people sort of got this question wrong, a part of the Constitution but has no legal effect, not a part of the Constitution and has no legal effect either, a part of the Constitution and has the same legal effect as any other part, a part of the Constitution but has no legal effect independently of any other part. All right. What we definitely know is that the preamble is a part of the Constitution. So this option is eliminated. What else is left is the word legal effect. Legal effect means two things. First, can the preamble be implemented or enforced as it is? And second is, can the legislature or the executive or the judiciary, the legislature, the executive, can make a law or an order only based on the preamble? And can the judiciary give a judgment only based on the preamble? The answer is no. But can the legislature make a law basis the preamble and something else which they have to implement? Yes, because the legislature can only make laws on something which is in the 7th schedule, right? Or which is in fundamental rights, specifically directing the parliament to do so. There is no other legislative power in the Constitution. So the preamble is not giving legislative power anyway. So it is a part of the Constitution and has the same legal effect as any other part is wrong, because what you are saying here is the preamble and the fundamental rights have the same legal effect. The answer is obviously no. Apply the devil's advocate theory. Now you are left with option A and option D, a part of the Constitution but has no legal effect, a part of the Constitution but has no legal effect independently of other parts. Yes, between A and D, D seems to be the better choice, because you can make a law on the basis of the preamble and something else which is enforceable. The judiciary can give a judgment on the basis of the preamble and something else. The judiciary can rely on the preamble, but never just the preamble while delivering a judgment. So on its own does not have a value. With something else, the plus X principle, it does. The correct answer here would be D. All right. The correct answer here would be D. Sorry. This would be D. Now, the This is mistaken here because I have missed a question. That was the Aadhaar question that I have missed here. That's because it is outdated and there are improved Supreme Court judgments. The answer will still be D. Now, question 11. Which of the following categories of fundamental rights incorporates protection against untouchability as a form of discrimination? Right against exploitation, right to freedom, right to constitutional remedies, and right to equality. Now, you have to solve this question by a simple devil's advocate theory. Argue the opposite. What is untouchability? Untouchability is treating two sets of people differently. Untouchability is treating two sets of people differently. This is a social discrimination largely based on caste. All right. Option number A. If I am treating A and B differently, am I necessarily exploiting them? If I am treating B lesser than A, take a form of untouchability that, let us say, A and B have come to your house and you're giving food in a ceramic plate to A, but in a steel plate to B, and you're making the person B sit on the floor. Are you necessarily exploiting B? No, because exploitation talks about wrongful labor, talks about child employment. Definitely no. Are you forcing B to sit there? No. Are you forcing B to do what you're telling the person B to do? No. Are you violating B's interests? No. Are you violating B's freedom? No. B has very much the right to walk out of there. Are you stopping B from going to court just because you're treating them differently? No. The court doesn't discriminate on untouchability. What you're essentially doing is treating people unequally. So your option answer D is your correct answer. Okay? There you go. Now, 12. Which part of the Constitution of India declares the ideal of a welfare state? A welfare state is that the government has to work in the interest of emancipation of the people by providing certain improvements. A. DPSP, B. Rights, C. Preamble, and D. The 7th schedule. Now, the 7th schedule is basically your lists, union list, state list, and concurrent list. You have to think about it as which of the following primarily, majorly deals with the concept of a welfare state. Majorly, that is what their purpose is. Now, laws that you can make under the union list, the state list, and the concurrent list could be welfare and non-welfare in nature. So this is not the option. Preamble does talk about welfare in the form of socialism, but also talks about other things. So this is not the answer. Fundamental rights, on the other hand, are minimum political guarantees against the state for the citizens. This is not the answer. This is what you should do if you can, if you have the resources, time, and the political will. So your answer is A, directive principles. That was a very easy question and you can easily solve it. Question 13. You'll be able to find contradictions in this question. With reference to the provisions contained in Part 4 of the Constitution, which of the following statements is or are correct? 1. They are enforceable by a court. 2. They are not enforceable by a court, which means 1 and 2 cannot exist in the same option combo. UPSC was smart to figure that out. 3. The principles laid down in this part are to influence the making of laws by the state. Let's simplify this. This means, can the legislature make a law on the basis of a directive principle? Yes. And we've done this on numerous occasions. Definitely. They shall be enforceable by court, they shall not be enforceable by court. Obviously, they are not enforceable in a court because of rule number 1, democratic mandate. If you force the government to implement a welfare measure, you're taking the mandate through which they've been elected to decide what, in their opinion, is the appropriate welfare at the appropriate time. So they shall not be enforceable in any court is definitely right. 3 is definitely right. 1 is wrong. If you see, you can eliminate this here, and your answer becomes D. Your answer is 2 and 3. Okay, that is your answer. There you go. Next, question number 14. In India, separation of judiciary from the executive is enjoined by, which means where is it given, where is it mentioned? The preamble, directive principles of state policy, the 7th schedule, and of course a conventional practice. Now, it's definitely not the 7th schedule, because the 7th schedule talks about legislative powers. Here we are talking about separation of the executive from the judiciary, basically saying we should have more judges so that DMs don't have to perform judicial functions. Fair enough. This seems like something which is fairly technical and fairly detailed and fairly specific. That means the preamble will not contain it, because the preamble usually speaks about larger objectives. We are now left with directive principles and conventional practice. Separation of powers is important enough to not just be a conventional practice, because you could discontinue it at any point of time, and it is not explicitly mentioned in the constitution, which is why it says in India separation of judiciary from the executive. It does not say separation of powers. This is something that we should do. We basically are saying that because we do not have enough judges at the grassroots level, we have to make our civil servants become judges. So therefore, it of course is a burden to them, and of course we are not building the kind of impartiality that the judiciary should have. Now, for you to have more judges, you need to have more recruitments, more money to pay the judges, and more infrastructure, which fundamentally requires you to spend an X amount of money. That means only if the government is in a position to do this, will the government be able to spend money to fill the unfulfilled judicial vacancies. Sounds like a directive principle, and it is. Your answer should be B. Let us quickly check. Yeah. Question number 15. Other than the fundamental rights, which parts of the Constitution of India reflects the principles and provisions of the Universal Declaration of Rights, 1948? It's a 2020 question. So the question is, Universal Declaration of Rights obviously will have some reflection in India. Of course, our fundamental rights should be inspired from the Universal Declaration of Human Rights. What else should be? Preamble, directive principles, and fundamental duties. Now, the simplest way to do this is, are there any common factors between fundamental rights, preamble, directive principles, and fundamental duties? A lot of people did actually get this question wrong. Preamble is an obvious choice, because preamble talks about equality, fundamental rights talk about equality, preamble talks about dignity, fundamental rights have implications to dignity and liberty and freedom of thought expression. So definitely the preamble is there, right? Definitely the preamble is there. Because you see, preamble was mentioned in all the four options except B. So we tried to eliminate the preamble. Preamble cannot be eliminated. It is definitely one of the options. Now, let's look at directive principles and fundamental duties. Obviously, nobody has any idea what is written in the Universal Declaration of Human Rights. But we do have an idea of the relationship between rights, directive principles, and duties. Are they correlative to each other? Of course they are. If you have a right, you will have a DPSP and a duty to help you with it. If the government is guaranteeing the citizen a right, then they also have to try to implement that right through a directive principle, and the citizens must be motivated to accept the right and be a part of it. The best example of this is the 86th Constitutional Amendment, wherein 26A added right to education. Directive principles were changed from 6 to 14 to 0 to 6, so that the state could then further aspire for other forms of education. And the latest fundamental duty was added to motivate parents to send their children between 6 to 14 to schools. So definitely your answer then becomes 1, 2 and 3, right? So preamble, directive principles and fundamental duties, all of them are correlated to each other. So therefore, yes. Your answer here should be D. This was a tricky question, but could be done. Now, question number 16. This was a tough question. A lot of people had issues with this. Let us try and solve this question with some logic around it. So in India, the legal services authorities provide free legal services to which of the following types of citizens? Person with an annual income of less than 1 lakh, transgenders with an annual income of less than 2 lakhs, members of other backward classes with an annual income of less than 3 lakhs, all senior citizens. Now, out of all of this, we try to think what principle, what logic, what trick could apply. Seems like all here is too much of an extreme, because if I argue the counter to it, that even extremely rich senior citizens should be guaranteed free legal services. Now think about what are the other benefits that super senior citizens get. They get discounted air travel, they get discounted rail travel, they get perhaps a pension at some point, which is also at a discounted rate. But you would rarely hear of a service which is completely free, but only and only for senior citizens. That doesn't quite sound right. You may want to give it to people who are senior citizens but may come from a disadvantaged background, but to give an entire community of senior citizens something completely free sounds a little too expensive and a little too overwhelming. So I would take a guess and I would say, you know what, option number 4 seems odd, because when I compare it to the other benefits given to senior citizens, I can't think of something that senior citizens are given entirely free of cost by the government. So any option which has 4 in it seems to get eliminated, right? It seems to get eliminated. Now we have 1, 2 and 3 left. Okay, think about it. Okay, transgender benefits, perhaps a lot of us may not be aware of. Let's try and focus here on members of other backward classes with an income of less than 3 lakh. Now think about it. We know that other backward classes are essentially now on a non-creamy layer basis. And for the non-creamy layer, there is an income criteria also, that if your income is above a certain amount, then you would be creamy layer and you may not be entitled to get the OBC reservation. This income limit is definitely not as low as 3 lakhs, because if it was as low as 3 lakhs, then you would be only able to give a very small section of people OBC reservation. Now, you may not know the exact number, but you would definitely think that 3 lakhs is too less for a non-creamy layer. Now, can you have 2 different income layers for 2 different benefits but to the same community? 2 different layers of 2 different benefits but to the same community. That in one case, OBC income should not be more than this, but if you want free legal services, it should be further below. That doesn't sound right, because the same caste is being subjected to 2 different restrictions and 2 different facilities, thereby violating equal protection of law, because you're not treating them similarly as they come from similar circumstances. Which means I would take a guess and I would think this is also wrong, and therefore I would try and mark what is called option number A, which is 1 and 2 only, because that's the only option which is left. A tough question. Only attempt it when you have about 5 minutes to think about it. Otherwise, try not to. What did I do? I equated it with some common sense. I equated it with things that we see around ourselves. And that is how I was able to conclude to Option A, which is 1 and 2. All right, next, there you go. Which article of the Constitution safeguards one's right to marry a person of one's choice? The right to marry somebody. Article 19 is freedom of speech and expression, 21 is life and liberty, 25 is religion, 29 is cultural and educational rights. Now let's eliminate by devil's advocate. Definitely not Article 29, because marriage has nothing to do with cultural and educational rights, because a person may not form, this is largely for minorities, and we're talking about marriage of anybody. This means we're also talking about marriage of anybody, whether they are following a religious custom or not. So there you go, 25 is out. Article 19 and 21 can be a conflict. Article 19 is the freedom to express yourself. Article 21 is the freedom to life and liberty. If you're not allowed to marry as per your own choice, then your liberty seems to be taken away. Your life may seem to be incomplete. This seems to be more overwhelming than Article 19. Therefore, option B, Article 21 is your correct option. Okay, there you go. Next question. The next question. In the context of polity, which one of the following would you accept as the most appropriate definition of liberty? Right? We have to apply the devil's advocate theory, otherwise we won't be able to come to a conclusion. Otherwise, this is clearly given in your NCERT textbooks as well. Okay. Now, protection against the tyranny of political rulers. Fair enough. Let us say you're protected against the tyranny of political rulers. That means political rulers will not, perform any violations on you. Fair enough. Does that still give you the freedom to do whatever you want to? No. Opportunity to do whatever one likes. Does that mean your liberty is unrestricted without any question whatsoever? No. You're left with option B and D, absence of restraint and the opportunity to develop oneself fully. Option C and option D has a difference. Option C means both positive and negative development. Option D only means positive development. Option B says absence of restraint. Does this mean that there are no restrictions on what you want to do and what you would ever do? No. Liberty will have certain restraints, but those restraints have to be justified through law and they have to be reasonable. So your option becomes D, the opportunity to develop oneself fully. Okay, important. Next, tough question, but can be done. There is a glaring contradiction in this question. Very tough, but very, very interesting question. As per the Right to Education Act, to be eligible for appointment as a teacher in a state, here state means UPMP, a person would be required to possess the minimum qualification laid down by the concerned State Council of Teacher Education. Let us simplify this. As per the Right to Education, to be eligible for appointment as a school teacher, you should have minimum qualification prescribed by the State Council of Education Research and Training, or State Council of Teacher Education, not even SCERT, State Council of Teacher Education. Okay. Second option, as per the Right to Education Act, for teaching primary classes, okay, as per the Right to Education Act, for teaching primary classes, which means primary teacher, is required to pass a teacher's eligibility test conducted in accordance with the National Council of Teacher Education guidelines. Third, in India, more than 90% of teacher education institutions are directly under the state governments. This means they're not under the center and they're not privately owned. Okay, let's look at the third statement first. The third statement is saying 90% of B.Ed colleges in India are state government colleges. Now think about what do you know? That most colleges and universities in India are actually owned by the private sector, whereas most schools in India are owned by the government. If most colleges are owned by the private sector, then how is a majority of teacher education college owned by the state government, right? And think about it. I'm sure you would know at least 5 people in your life who've done a B.Ed. And think about where would have they done their B.Ed from? It would most likely be from a private college, which means option number 3 is definitely wrong. Now you're left with either 1 and 2 or 2, right? Either 1 and 2 or 2, which also means 2 is definitely correct. We've got to figure out whether 1 is correct or not. Now look at this very carefully. Option 1 and option 2 are actually contradictory to each other. Option 1 says right to education says anybody to be eligible for appointment to any class, any school teacher should have minimum qualifications as per the state council. Here it says anybody as per the RTE Act who wants to be a primary teacher must pass a teacher eligibility test as per the National Council for Teacher Education. If you think about it, they're contradictory. And we know 2 is definitely correct. That means 1 is incorrect. Let me tell you why is this contradictory. Because RTE is a national law. If it is a centrally made law, then how would you ask it to conform to a state regulator guidelines? And second, this would also mean recruitment of teachers in government schools. Since when do government school recruitments or government job recruitments only work on minimum qualifications? I'm sure at least some of you would have heard of central teachers eligibility test, state teachers eligibility test. That means there is some form of a written test. Here it says you just need to have minimum qualification. A national law requires qualification guidelines on the basis of the state. Here it is through the national guidelines because it's a national law. Therefore, they're contradictory, which is why between 1 and 2, you would choose 2 only, right? That's one way to go about it. If one option is 1 and 2 and the other is 2 only, which means 2 is definitely correct. And if 1 and 2 are contradictory to each other and 2 is definitely correct, your answer automatically becomes 2. You didn't even have to come till here if you had eliminated just option number 3. So the answer should be B, 2 only. Let's check. Yes. Okay. Which of the following are regarded as the main features of rule of law? Which of the following are regarded as the main features of rule of law? We'll apply the devil's advocate theory, the contradiction approach. Limitation of powers, equality before law, people's responsibility to the government, liberty and civil rights. Let's first glance to the options. Let's see if we can eliminate something. 1 is present in 3 options but not 1. Can we eliminate 1? No, we cannot eliminate 1. 1 is definitely correct because rule of law means equal protection of law, equality before law, absence of discretion, fairness of law, fairness of redressal, everything which means power originates from the law, right? Now, out of this, which seems very, very odd? People's responsibility to government. People's responsibility to government has nothing to do with a law which is supposed to govern government. And people's responsibility to government sounds like a little bit of fundamental duties, and fundamental duties are not enforceable in the first place. So let's eliminate wherever do we find option number 3. So A is eliminated and D is eliminated. Now we are left with 2 and 4 and 1, 2 and 4. Just we have to check that 2 and 4 is therefore correct. Just 1 is correct or not. 1 is definitely correct because rule of law places restrictions on the law so that it can be just. Restrictions on the powers of its application, on the powers of it to be not applied arbitrarily or in excess. So the answer should be C, 1, 2 and 4. Right? There we go. Next. Which of the following reflects the nicest appropriate relationship between law and liberty? Again, we have to argue the opposite here so that we can come to an answer. First, if there are more laws, there is less liberty. B, if there are no laws, there is no liberty. If there is liberty, laws have to be made by the people. If laws are changed too often, liberty is in danger. Let us try to eliminate the options, right? If, for example, let's start from the bottom. If laws are changed too often, liberty is in danger. Not really. Laws could be changed too often to further enhance liberty also. You may want to keep amending your laws to give more and more powers and safeguards and freedom to the people. That's not necessarily the case. If there is liberty, laws have to be made by the people. Not necessarily. If there is liberty, law could also be given to you by a dictatorial regime, by a monarchical setup, or even by the government. People don't have to necessarily make the laws for there to be liberty. As long as there are laws, there should be some form of liberty. If there are more laws, there is less liberty. If you think about it, that's not necessarily the case, because more laws will give you more forms of freedom also. That is also possible. More laws can give you more sorts of freedoms in more and more dimensions. One can give you technological freedom, one can give you occupational freedom, one can give you cultural freedom, one can give you religious freedom. There could be 10 different laws around it. What is definitely sure is, if there are no laws, then there is no liberty, because then there is no way to guarantee you that kind of freedom. So therefore, B should be the correct answer in this scenario, and if B is supposed to be the correct answer, it will be. Next, right to privacy is protected as an intrinsic part of right to life and personal liberty. Which of the following in the Constitution of India correctly and appropriately implies the above statement? 14 and 42nd Amendment, 17 in DPSP, 21 in freedoms guaranteed in Part 3, 24 and provisions under the 44th Amendment to the Constitution. What we know for sure is right to privacy originates from 21. Don't even think of anything else. Automatically 21 and the freedoms guaranteed under it under Part 3. This would be your correct answer. No problem at all. Okay, so there you go. Next, which of the following objectives is not embodied in the preamble to the Constitution of India? Which means this has to be explicitly mentioned in the Constitution. It cannot be derived under any circumstances. Liberty of thought, economic liberty, expression and belief. Apply the devil's advocate. If there was economic liberty, then anybody would be free to do whatever they want to economically, be it sell guns, drugs or anything else. Thought, expression, faith, belief sounds like things that you should have in the preamble because they are not essentially crossing a line. So therefore, option B is the correct answer because it is not embodied. Simple. Now, the mind of the makers of the Constitution is reflected in which of the following? I've discussed this as a trick when we're doing the preamble. Remember this, if the subject matter cannot be legally defined, it is usually an adjective for the preamble. If it is legally definable, then it is usually rights or directive principles. Anyways, the mind of the makers of the Constitution is reflected in what? The mind means what are you trying to aspire to? What are you trying to achieve? Preamble, directive principles, fundamental rights and duties. They are fundamental rights only look at political democracy. Directive principles look at socio-economic democracy. Duties are things that we have to do for the citizens, and fundamental duties did not even exist When we are talking about the makers of the constitution, this was added much later. This is automatically out. DPSP is only about what the government should do. This is about what the citizen should be given. This is a combination of everything, and therefore the answer is the preamble. Okay. One of the major implications of equality in society is the absence of. For equality to exist in society, what doesn't need to exist? Privileges, restraints, competition, and ideology. Let's try and understand. If you want A and B to be equal, what should not be present in society? If A and B have two different ideologies, that does not make them unequal in the first place. If A and B have to compete with each other, that does not necessarily mean that they're unequal. If A and B have to be restricted, that does not necessarily mean that they're unequal. But if one of them has privileges, that means that there is an inherent advantage or an inherent heads up. Think about it. That's what happens usually. Use practical examples. If somebody is right wing and somebody is left wing, that does not necessarily make them unequal. If you are in an open market, India is open market, India has freedom of occupation, does that necessarily make businesses unequal? No. When we restrict people from doing a certain kind of a job, from let us say employing child labor, are we putting people at a disadvantage? No. But for example, let us say somebody has a caste privilege. Does that necessarily make people unequal? Yeah, it does. So privileges is a problem. So if there are no privileges, there definitely is equality. There you go. Now, a controversial question, but an important one. The right to vote and be elected in India is. Now, the right to vote and be elected. If it was just right to vote, then we would have spoken about it only in the context of it being a constitutional right, because your Election Commission 324 around talk about universal adult franchise. But the right to be elected, right? The right to be elected. The constitution only gives you the eligibility criteria. It does not give you a right. It tells you if you want to be an MP or an MLA, you should be able to do A, B, C, D, E. It does not say that you have the right to be an MP or an MLA. And you have the Representation of People's Act, which give you detailed restrictions, detailed conditions on who can or cannot be an MP or an MLA, right? So therefore, it is not just constitutional, but it is also legal, and the legal right is far more exhaustive. That is why it is a legal right, because whatever is a constitutional right is also usually a legal right. So here, this is just constitutional, this is legal. Constitutional plus legal will always be a legal right. Okay, always remember this. So the answer here should be D. Next, in the context of India, which of the following is the correct relationship between rights and duties? Rights are correlative with duties. Rights are personal and hence independent of society and duties. Rights, not duties, are important for the advancement of the personality of the citizen. Duties, not rights, are important for the stability of the state. Now, option C and option D are contradictory to each other. What option C is saying is, rights are important, but duties are not important for the development of the citizen. So, when a duty says you should have scientific temper, it automatically develops your personality. So, this is wrong. Right, duties, not rights, are important, which means it does not matter if people have rights or not. That is not going to help in the stability of the state, which means that if people are not protected against exploitation, it does not matter, because that does not have any effect on the stability of the state. That is actually incorrect. You require fundamental rights to stabilize the state. Rights are personal and independent of society and duties? No, because rights exist in a social context. Rights are correlative with duties. We've done this before. Absolutely. The correct answer is A. Which of the following statements is correct? Rights are claims of the state against the citizens. Rights are privileges which are incorporated in the constitution. Rights are claims of the citizens against the states. Rights are privileges of a few citizens against the many, which means it's about, this says it's citizen versus citizen. Here it is about the citizen stronger than the states. Here it is privileges which are in the constitution of the state. Privileges are always for a few people. Rights are claims of the state against the citizens. Citizens are always greater than the state. They are the claims of the citizens against the state. Questions like these should not take you more than 30 seconds. Question number 29. Which of the following are envisaged by the right against exploitation in the Constitution of India? Which of the following are envisaged by the right against exploitation in the Constitution of India? Now, protection of traffic in human beings and forced labor, abolition of untouchability, protection of the interests of minorities, prohibition of, in the interest of employment of children in factories and mines. All right. Now let's understand this. We've got 1, 2, 4, 2, 3, 4, 1 and 4, 1, 2, 3 and 4. All right. Which of the following is correct? So we know that we're looking for the correct option. Now let us see. We've got very easy, protection of the interests of minorities. You have to apply the devil's advocate. This is positive in nature, that we have to give them more support to further enhance what makes them a minority. Exploitation is fundamentally negative, that we have to prevent anything negative happening. So any option which has 3 is out. Now we are left with 1, 2 and 4 and 1 and 4, which means 1 and 4 is definitely correct. Now, abolition of untouchability, this has been a question that has already been asked before. We just discussed this. Untouchability and exploitation are not necessarily correlative, that just because you practice untouchability does not mean you're exploiting somebody. So the option becomes C, 1 and 4, right? Done. Next, question number 30. Very good question. Which of the following statements is or are true of the fundamental duties of an Indian citizen? Which of the following are true of the fundamental duties of an Indian citizen? A legislative process has been provided to enforce these duties. 2, they are correlative to legal duties. A legislative process has been provided to enforce these duties. 2, they are correlative to legal duties. Now think about it. What is it saying? It is saying that we have a procedure to implement these fundamental duties by law. There is a process which has been provided where? Assumed in the Constitution. There is no such thing. 2, they're correlative to legal duties, which basically means that if there is something which is a fundamental duty, it must necessarily also be in a law which makes it mandatory for people to follow it. That would essentially make it enforceable. Both are incorrect. The answer therefore becomes D, neither 1 or 2. Neither 1 or 2. All right. Now 31. Consider the following statements. Which of the following consider the following statements. With reference to the Constitution of India, the directive principles of state policy constitute limitations upon, which means A, legislative function, and second, executive function. What is this question trying to say? That directive principles are constituting limitations upon, which means a law cannot be made on a directive principle. An executive order cannot be made on a directive principle. Why? If they want to, they can, which means both are incorrect. The only thing it constitutes limitation upon is enforcement in a court of law, which means both the options are incorrect, and your correct option would be D, which is neither 1 or 2. Next, which principle among the following was added to the directive principles of state policy by the 42nd Amendment to the Constitution? 42nd Amendment is 1976. We've all remembered this. Equal pay for equal work for both men and women, participation of workers in the management of industries, right to work, education and public assistance, securing the living wage and human conditions of work to the workers. Now, it is very difficult for people to remember this, people to remember what was added under what amendment, but let's think about it. If the 42nd Amendment was in 1976, and 1976 is usually called the Emergency Amendment, what immediately preceded the emergency was nationalization of industries, and the closest that comes to nationalization is participation of workers in the management of industries. This is tough, this is a fluke. I would have done this like this, but again, even I would have marked something else if I was writing the paper. This is a tough question, only and only memory could have helped you with this, but if not, I would have taken a long guess shot and tried to solve with option number B. Let us check if that is the correct option. Yes, it is. Now, consider the following statements regarding directive principles of state policy. They spell out the socio-economic democracy in the country. The provisions contained in these principles are not enforceable in a court. Do they spell out socio-economic democracy? Yes, they do. Are they enforceable in court? No, they are not. Both the options are correct. The answer is C. You see how easy the questions are? You don't have to worry too much about it. These are 10-second questions. There you go. To uphold and protect the sovereignty, unity and integrity of India is a provision made under what? First things first, it's definitely not a right, because this would mean it has to be done by the citizens. It has to be done by the state against the state. It has to be guaranteed to the citizens. It is a call action. It's a call to action. If it's a call to action, it will never be a fundamental duty. It will always be either a DPSP or a duty. It will never be a fundamental right. To uphold and protect the sovereignty, unity and integrity of India is a provision made in the, now not the preamble, because the preamble talks about individuality and dignity and liberty. It talks about, now remember, it's a provision, it has to be explicit in nature. Sovereignty, socialism, democracy, republic, secularism, all of this is mentioned together in the preamble. So preamble is not the answer. Rights is not the answer. Now it's a choice between directive principles of state policy and fundamental duties. Now, directive principles of state policy is to tell the government to do something that they are currently not doing so that India becomes better. Isn't this which is a precondition for what the government should do? This is the basic job of the government, to protect the sovereignty of the country. You don't have to make it optional for the government to protect the sovereignty of the country. Therefore, directive principles can't be the answer. Your answer is fundamental duty, right? Because as citizens, we also have a role to play in the integrity of India. Okay, tricky question, but still can be done. Yeah. Now, consider the following statements. A constitutional government is one. Places effective restrictions on individual liberty in the interest of state authority. Places effective restrictions on authority of the state in the interest of individual liberty. Both are contradictory, which means both cannot be correct at any given point of time. Places effective restrictions on individual liberty, which means in the interest of the state, which means here the state becomes more important than the citizen. Places effective restrictions on the authority of the states in the interest of individual liberty. Here the citizens are stronger than the states with effective restrictions. The answer should be B, 2 only, right? Always look for contradictory statements. Next, in the Constitution of India, promotion of international peace and security is included in the what? Simple, not the preamble, because the preamble does not talk about international peace or security. Preamble is for what India is. International is the word not mentioned in the preamble. The ninth schedule is about laws that cannot be judicially challenged unless they violate basic structure. We are talking about promotion of something, not a law. This is out. You are left with DPSP and fundamental duties. There's a simple two test that I've taught you in the Magna Carta lecture. Who implements this and what is the kind of language that is used? Who will promote international peace and security? The citizens or the government? The government would. That means it's a directive principle, and promotion is a formal adjective. Therefore, again, directive principle. So the answer should be, the answer should be B, directive principles of state policy. Next, 37. Economic justice is as one of the objectives of the Indian Constitution has been provided in the what? Preamble and fundamental rights, preamble and directive principles of state policy, fundamental rights and the directive principles of state policy, none of the above, right? Now, fundamental rights are essentially political rights. So economic justice as a term is not mentioned. This has to be in the constitution with some degree of explicit mention. So obviously this is not the answer. If it's not fundamental rights, then it also cannot be a combination of fundamental rights and the preamble. Now you're left with B and D. The preamble does talk about justice, social, economic and political, and directive principles also talk about economic justice in the sense that 39B and C are essentially enabling provisions of the same. The answer should be B, right? Because this is something that the state should try and provide through equal pay for equal work, prevention of concentration of resources and wealth, and so on and so forth. Okay, so the answer here should be B. 38. According to the Constitution of India, which of the following are fundamental for the governance of the country? Which means this is crucial, this has to be explicitly done, this is enabling to the Constitution to make the country better, right? Governance is what the government can do or how better can the government be. Out of all of these, what are the instructions to the government to do something better? Directive principles of state policy. Without even thinking twice, the answer would be directive principles. Rights are to ensure that citizen interests are not taken away. They're the bare minimum that the citizen should get. Duties are about citizens. So anything which has duties automatically gets eliminated, rights gets eliminated. What you're left with is directive principles of state policy. Next. With reference to the National Legal Services Authority, consider the following statements. Its objective is to provide free and competent legal services to the weaker sections of society on the basis of equal opportunity. It issues guidelines for the state legal service authorities to implement legal programs and schemes within the country. Now, I know we've done a question like this before where there was a question on what is the eligibility criteria, which is also why I keep telling you how important are questions on past year papers, right? Now, so does it provide free and competent legal services to weaker sections of society? Yes, obviously it does, because that's what the whole concept of free legal services is, because most people can't afford a lawyer. So that everybody has a lawyer, so that there is a free and a fair trial, you would certainly require the authority to assist. So yes, the first part is definitely correct. The second is it issues guidelines to state legal service authorities. Anything which is national can always issue guidelines to the states. Now, NHRC can issue guidelines to state human rights commissions. National Legal Services Authority can issue guidelines to state legal services authority. Absolutely, because these are statutory and both of them are correlated. The answer would be C, both 1 and 2. Because guidelines are not legally binding in the first place, and 2, what are you issuing guidelines for? You're issuing guidelines to implement legal programs and schemes. So if there is a scheme which is funded by the center, implemented at the state level, the center can ask the National Legal Services Authority to coordinate the implementation at the level of the states. So why not? So yes, the answer here should be C. Question number 40. with reference to the constitution, with reference to, sorry, consumer rights, with reference to consumer rights or privileges under the provisions of law in India, which of the following statement is or are correct? Consumers are empowered to take samples for food testing. When a consumer files a complaint in any consumer forum, no fee is required to be paid. In case of death of a consumer, his or her legal heir can file a complaint in the consumer forum on his behalf. We look at option combos 2 and 3, 1 and 3, 1, 2 and 3. There's only one option which only, option number 3 is mentioned in 3 out of 4. Can we eliminate option number 3? In case of the death of a consumer, his or her legal heir can file a complaint in the consumer forum. Let's think of a practical example. Let us say somebody buys a car and let us say the car's seat belt is not working, the car's airbag is not working, because of which the person gets into an accident and is not safeguarded with the safety features of the car. Does it violate principles of consumer law? Yes, it does. Option number 3 is absolutely correct. You cannot eliminate it. Now, when a consumer files a complaint in a consumer forum, no fee is charged. That means rival companies can file fake cases. That means precious time of the court can be violated. That means anybody and everybody for maybe any wrong or no wrong can approach the court, can lead to overburdening of it. This definitely sounds wrong. So any option which has 2 gets eliminated. Now you're left with 1 and 3 only. We've just proven that 3 is correct. 1 and 3 and 1 and 1 only means 1 is definitely correct. Of course, you're empowered to take samples for food tasting, right? So your answer should be C. 41. The Green Tribunal Act, the National Green Tribunal Act of 2010 was enacted in consonance with which of the following provisions of the Constitution of India? Okay. The right to a healthy environment construed as a part of right to life under Article 21. The provision of grants for raising the level of administration in the scheduled areas for the welfare of scheduled tribes under 275(1). Powers and functions of the Gram Sabha as mentioned under Article 243A. Alright. Now, just to prove it, they've given you the article numbers also. We've got 3 options. We've got 3 in 3 options out of 4. Can we eliminate 3 options? Can we eliminate option number 3? Powers and functions of the Gram Sabha under 243. Does the Gram Sabha have any powers with respect to settling environmental disputes? Not at all. The Gram Sabha will only have those powers which the state government will give the Gram Sabha upon devolution from the 11th schedule. So the National Green Tribunal, which is your national environmental agency, has nothing to do with the powers of the Gram Sabha, which are actually dependent on state will. So 3 is definitely wrong. Any option which has 3 gets eliminated. Your answer is 1. Similarly, provision for grants for raising the level of administration in the scheduled areas and welfare of scheduled tribes. Administration and welfare of scheduled tribe would mean doing things that aid in their development. This settles environmental disputes, and therefore Article 21 also includes the right to a healthy environment. You can apply this with a simple example. If the National Green Tribunal has the powers to shut down diesel cars, what has diesel cars to do with scheduled castes and scheduled tribes or scheduled areas or powers of the Gram Sabha? Nothing. But diesel cars have definitely something to do with the right to a healthy life. So it has to be played accordingly. Okay? Now, next. Consider the following provisions under Directive Principles of State Policy as enshrined in the Constitution of India. Securing for citizens a uniform civil code, organizing village panchayats, promoting cottage industries in rural areas, and securing for all the workers reasonable leisure and cultural opportunities. Which of the following are Gandhian principles that are reflected? 1, 2, 4, 2 and 3, 1, 3, 4, 1, 2, 3 and 4. Except for option number B, 4 is present in all. Can we eliminate option number 4? Gandhian means it has to be orthodox and it has to be grassroots, and therefore we have to look for option number 4. Securing for all workers reasonable leisure and cultural opportunities. That has nothing to do with grassroots or conventional. So definitely 4 is wrong. So you are eliminating 4. You're only left with 2 and 3. Organizing village panchayats and cottage industries. Again, Uniform Civil Code is not grassroots or conventional. It is therefore liberal and intellectual, because it is also not about equal distribution. So that's one way to go about it. We've discussed this before in our classes also. Gandhian is anything which is orthodox or conventional. Socialist is equal distribution. Whatever is left is liberal or intellectual. 43. Which of the following is or are amongst the fundamental duties of citizens laid down in the Indian Constitution? To preserve the rich heritage of our composite culture, to protect the weaker sections from social injustice, to develop scientific temper in the spirit of inquiry, to strive towards excellence in all spheres of individual and collective activity. Select the correct answer. So let us see if there's something that we can eliminate. 1 and 2, 2 only, 1, 3 and 4, and 1, 2, 3 and 4, right? So can we eliminate 1? Is 1 a fundamental duty? 1 is definitely a fundamental duty, so we cannot eliminate 1. To protect weaker sections from social justice. If somebody is getting social injustice, to protect weaker sections from social injustice, let's think of an example. So if somebody is being discriminated on the basis of caste, how do we stop casteism in a society? A law has to prevent that from happening. That means the government has to make adequate measures. So 2 is definitely not a fundamental duty. So if 2 is not a fundamental duty, can we eliminate 2? A, B and D. Yes, we can eliminate 2. Then your correct answer becomes C, right? Your correct answer becomes C, because it's only 1, 3 and 4. There you go. Which of the following provisions of the Constitution have a bearing on education? DPSP, rural and urban local bodies, 5th schedule, 6th schedule, 7th schedule. 1 and 2, 3, 4 and 5, 1, 2 and 5, 1, 2, 3, 4 and 5. Tough question, but a good one. All right. So except for option number B, 1 is present across all the 3 options. Let us see if we can eliminate 1. No, we can't, because directive principles do have provisions with respect to 0 to 6 years. So this is definitely related to education. Can we eliminate 2? Because except for B, everything else also has 2. Rural and urban local bodies. What about rural and urban local bodies have anything to do with education? Education is in the concurrent list, and if education is in the concurrent list, which means both the center and the states should have the power to do this. But do rural and urban local bodies have anything to do with education? Maybe, maybe not. Okay, let's keep it here. Does 7th schedule have anything to do with education? Yes, because it contains the concurrent list which has education, which means B, C and D all have the 7th schedule. All right, which means if 5 is here and all of the options, if you see 3, 4 and 5, at least 3, 4 and 5 is here, 3, 4 and 5 is here, which means either 1, 2 and 5 or 1, 2, 3, 4 and 5, right? Now think about it. This is where you use a little bit of logic to get to the right answer. See, see the leftover combinations. We've got rural and urban bodies. 1 is definitely correct, 5 is definitely correct. We have to check for 2, 3 and 4. Okay. Now between 2, 3 and 4, we are left with 2 is common to both C and D, which means 2 is definitely right. So rural and urban bodies is right, We are now left with third and fourth, which is fifth and sixth schedule. So 1 is right, 2 is right, and 5 is right for sure. Now we are left with fifth and sixth schedule. Now with fifth and sixth schedule, do we have any provisions with respect to education in the fifth and sixth schedule? Well, opportunities for development, special councils to be set up, special opportunities have to be given for local development. Yes, because if rural and urban local bodies have to be given powers, rural and urban local bodies are local self-government. Local self-government also gets applied to one of the two schedules, and this is another form. So local self-government gets applied to the fifth schedule with greater powers to the Gram Sabha. So if rural and urban local bodies definitely have education powers or have something to do with education, then fifth schedule would be. So if fifth schedule also does, then also does sixth schedule. So that is how you come to a conclusion, right? So your answer will be 1, 2, 3, 4 and 5. Consider the right to education, consider the following: right to education, right to equal access to public service, and right to food. Which of the following are human rights under the Universal Declaration of Human Rights? Second question in 2 years on Universal Declaration of Human Rights. Okay. Now let's look at the question. Again, does it sound like a reasonable human right? Now this is universal, this is a UN document. Does the UN talk about education? Of course it should. Equal access to public service? Of course it should. And right to food? Of course it should. See if you can eliminate one. You can eliminate 1 and 2. You can't eliminate 1 and 2. So the answer has to be 1, 2 and 3. Always assume the best and the most inclusive when it comes to questions like these. These are usually very comprehensive. Now in India, if a religious sect or a community is given the state of a national minority, what special advantages is it entitled to? Tough question, unlikely to be asked. It can establish and administer exclusive educational institutions. The President of India automatically nominates a representative of the community to the Lok Sabha. It can derive benefits from the Prime Minister's program, 15-point program. This 15-point program doesn't exist anymore. It has been transformed into something else, which is why it seems like an outdated question. Right, now let us see. What is definitely wrong? The President of India can now automatically nominate a representative of the community to the Lok Sabha. So anything which has 2 in it gets eliminated. Now you're left with 1 and 1 and 3. So 1 and 1 and 3 means 1 is definitely correct. Is 3 correct or not? Can it derive benefits? Can a scheme have special benefits to a specific community? Yes, why not? So the answer could be 1 and 3. But again, a tough question. It's okay if you don't get it. It's fine. Even I didn't the first time I read it. Next. Under the Constitution, which of the following is not a fundamental duty? To vote in public elections, to develop scientific temper, to safeguard public property, to abide the Constitution and respect its ideal. A fundamental duty is for everybody. Everybody is not entitled to vote, so everybody does not have the right to vote, and therefore you don't have a duty to vote in public elections. The answer obviously is A, without a doubt, right? So there you go. The answer is absolutely an A without any questions whatsoever, right? So with this, we're able to do the past 10-year questions of rights, duties, directive principles, preamble, territory and citizenship. As you can see, it's very easy if you know your basics. There's nothing complicated. Not a single question on any of the technicalities, not a single subclause has been asked. Your larger premise has been the nature of rights, Article 19, 14, 21, a little bit of exploitation and equality here or there, general principles of rights, enforceability of those, and you should be done and okay with these questions. Right? Thank you, and I'll see you in the next lecture where we cover the legislature, the executive, center state, emergency and local self-government. Thank you for watching.